Good morning. Today we are going to discuss section 9 to section 13. This will be the last lecture. This is the third lecture, you can say, on the topic of punishment. In the previous lecture, we have seen till section 8. Now what section 9 states? Limit of punishment of offense made up of several offenses. When a person has done an offense which is in parts and each part is a separate offense, then we are not going to take him or we are not going to charge him for separate part unless provided we are going to charge him only for one of his offense. The subsection second states that when the offense which he has done is coming under two or more separate definition, then also we are going to take it as one. The other clause of subsection 2 states that when several acts are done of which one or more than one would itself be constituting an offense, then also, or we can combine them, and if you combine them it is going to become a different offense, then also the person will be punished only for one offense. And what is the limit? The offender shall not be punished with more severe punishment than the court which tries him would award for any one of the offenses. Means here we are going to charge him with one section, though they are coming under separate definition, though they are separate parts, or if combined together they are becoming some separate offense. We are going to punish him for one section only, one offense only, unless otherwise provided. We'll take an example. A person has struck by stick 50 strokes he has given to some person. 50 strokes means each stroke, if you consider it as hurt, and if you punish him for each stroke 1 year imprisonment, then for 50 years he'll be inside. For hurt, he'll be inside for 50 years. So what we do, though he has given 50 strokes, we will consider it as one offense. But while he is giving few strokes to A, he has given one stroke to B. Then for one stroke, it will be a separate offense. And for the other 4-5 strokes, that will be one offense. Got it? Means he has committed hurt, voluntarily hurt towards A by 5 strokes. We are not going to calculate as 5. One section only. And he has given one blow only to B. That will be another charge. Got it? This is section 9. Next is section 10, which states that punishment for a person who is guilty of one or more several offenses and the judgment is like doubtful, then the offender shall be punished with the lowest. Our criminal law is little bit tilting towards the criminal. So when the punishment is like we are having one phrase, unless proven guilty, the concerned person is what? Innocent. Or the concept of benefit of doubt. If there is little bit doubt also in the case of prosecution, then it goes for the benefit of whom? The criminal. So little bit criminal law is favoring the criminal. So section 10 is also like that only, telling that punishment of person guilty of one of several offenses and judgment is stating that it is doubtful which of the offense, then the offender shall be punished for the lowest punishment. Means we have to charge him with that section. We have to punish him with that section which is having the less punishment. Now section 11 and 12, they relate with solitary confinement. Solitary confinement means a person will be kept solitary, alone in one cell. This is also a technique which we have brought so that he will think about what he has done. He'll be alone, so he'll be think about. But that should not be like very much rigors are there of keeping alone, because a person can overthink. He'll get stressed and he may become unsound. That also will be causing trouble for us. Therefore, we have put certain limits. Section 11 and section 12 relate with solitary confinement. Now what are the provisions? Where rigorous imprisonment is awarded, the court can state that from this rigorous imprisonment, he has to be put into solitary confinement for a certain period. But the limit is what? 3 months. So maximum a person can be put in solitary confinement for 3 months. And one scale is been given. And what is that scale? That if imprisonment, rigorous imprisonment only, we are giving solitary confinement. If imprisonment is there up to 6 months, then solitary confinement will be up to 1 month. If imprisonment is there from 6 months to 1 year, then solitary confinement will be up to 2 months. If imprisonment is there above 1 year, then the solitary confinement will be there for 3 months. We'll again discuss the scale. If imprisonment is up to 6 months, then solitary confinement is 1 month, up to 1 month. If imprisonment is 6 months above to 1 year, then the solitary confinement will be for 2 months. And if it is imprisonment is exceeding 1 year, then the solitary confinement will be 3 months. 3 months is the maximum solitary confinement which should be awarded by the judge. In the solitary confinement period, he will be in a separate room. We are going to see that he should not have contact with anybody else. That is the objective of solitary confinement. He should think about what he has done. That is the objective of solitary confinement. This is section 11, which states only about the scale and the maximum period, and that is 3 months. Next is section 12, which tells about the limit of solitary confinement. The person cannot be put for solitary confinement continuously. I told you the rigors, the effect are very adverse. So there is a limit put for solitary confinement under section 12. And what is that? The solitary confinement will in no case exceed 14 days at a time. Means at a time he will be there for 14 days. But if he is there for 14 days solitary confinement, then after 14 days he will be brought out from that cell. He will have an interval between solitary confinement of that same period, not less than that period. Means 14 days solitary confinement, 14 days outside. Like that. He should get same interval period. That is a limit put by section 12. One more concept is there, that if imprisonment which has been awarded to him is exceeding 3 months, means when the judge has given a sentence of imprisonment which exceeds 3 months, then the solitary confinement shall not exceed 7 days in any 1 month, with the interval again of 7 days, means the same period. We'll again discuss. When imprisonment is there for more than 3 months, if more than 3 months is there, then the solitary confinement will be at a stretch for 7 days only in 1 month. Means in this month it will be 7 days. But thereafter for 7 days he will be kept outside. Again for the 7 days he will be put inside. Means when the imprisonment is more than 3 months, what we have seen? We have seen that up to 1 month he can be given solitary confinement as per section 11. Imprisonment up to 6 months. And here what we are discussing, exceeding 3 months, isn't it? Therefore he comes either in the first scale, second or the third, whatever it may be. Whatever the amount of solitary confinement is been given to him, we have to follow a rule that the person will be put into solitary confinement for 7 days in a month, and same interval outside, that is 7 days outside, 7 days inside. Like that you have to do, but take care that 7 days in a month should be there. Otherwise what will happen, in this month, in the last week, you are going to put him into solitary confinement, and if this provision is not there, then what will happen? You will put him in the first week of the next month. Means again for continuous 14 days he will be there. So this care is being taken. Though 14 days is a limit, we have to take care that When imprisonment is above 3 months, then we have to give him only like 7 days solitary confinement, same interval outside. This is section 11 and section 12 telling about solitary confinement. When we should never forget, solitary confinement can be given only for rigorous imprisonment. A part of rigorous imprisonment can be solitary confinement. Now the last section, that is enhanced punishment for certain offences when a person is been previously convicted. Means once the person has done an offence and now again he is been catched subsequently for certain offences, and that is chapter 10 and chapter 17. Chapter 10 relates with offence relating to coins and chapter 17 relates with theft. Now for chapter 10 and chapter 17, if a person has been caught previously and he has been imprisoned for 3 years or upwards and again he has done the same offence, then now he will be punished with an enhanced punishment, that is more punishment, and that is life imprisonment or 10 years. Now why this section is there? Because now he is becoming habitual offender. We have to break his habit, isn't it? Therefore rigors are more here. Law states you are previously convicted, means whoever is convicted for counterfeiting coins and all, or for theft, and how much 3 years or upward he was punished, and again subsequently he has done the same offence, then he'll be punished for life imprisonment or 10 years. Got it? Now here we have completed the topic punishment. The next topic is of general exceptions. We are going to start from the next video. Okay, bye bye. See you in the next video.